Can you amend a buyer contract? Yes or no? There's a lot of debate going on in the industry about this over the last few weeks. In addition to that, the New York Times, the famous Debra Kamin, strikes again with more misleading information in just another hit piece on the Realtor organization. In addition to that, last week I did a long discussion and interview with NAR President Kevin Sears in a prior video, and the settlement's been approved, but 3 appeals have been filed in the 8th Circuit Court of Appeals. So, lots going on. Number one thing I want to cover today is, can you or can't you amend a buyer agreement after it gets signed at some point later? So I first want to review contract law. This is something that's been coming up over the last week. A contract is a legally binding agreement between 2 or more parties that creates mutual obligations enforceable by law. It involves 2 consenting adults. A contract amendment requires the consent of all parties to the original contract, just like the original agreement. The modifications should be clearly understood by all parties to avoid future disputes. So think about that. That's contract law from the law books, right there. That's clear. So these people that are out there opining and making comments on social media and saying things like, do not do it, no realtor should amend a contract. Well, I don't know as though we should be so sure, okay? And some of the people commenting on them are people that are very good, that have been all over these cases on top of things and have been right on a lot of topics. But I don't necessarily agree on this specific topic. However, I have to be careful what I explain to all of you, and I have to remind all of you that you should speak to your broker, speak to your attorneys, your local realtor association, etc., before making a decision on whether or not you want to amend a contract with a buyer. But this contract law explanation here makes it pretty darn clear that if 2 consenting adults agree to some sort of amendment, that should be okay. Now, obviously, if an agent tries to pull a fast one in the 11th hour and simply changes the agreement just because of more compensation potentially being offered from a seller or a listing broker, be careful there. You need to make sure everything's open, transparent, explained to the buyer, and the buyer is clear. But I am taking issue with some of these folks who have put this out and really made a bigger issue out of it. Now, I expect that Ketchmark would do that in an opinion. And then there was some professor from Buffalo who put out a whole dissertation about it, along with many other things back in early November. And that's part of what brought it into the limelight. But we have to remember that these plaintiffs' attorneys are always going to put in opinions and file things that will go against the industry and against realtors, despite what they may say publicly. So let's look at what the NAR General Counsel said about this topic. She put out, I thought, a very well-written email, but I'm going to read a couple parts of it. A written buyer agreement is like any other agreement. If you and your client agree to amend it, and there is full transparency, and if you follow the settlement and state law, you can amend it. Then there's some other talk. Keep in mind, the settlement says you can only be compensated as much as you and your client agree to in the written agreement. And then toward the end, there's a part that some are taking issue with. For example, the purpose of the amendment can't simply be to match whatever the seller is offering. Well, that leaves a little bit of gray area there. So let me tell a little story and explain what I'm hearing from some of our agents down in Florida, where they are seeing the possibility of this happening. I was visiting some agents last week, and a few of them were explaining to me how sometimes buyers change their mind, which I'm aware of. I've worked with thousands of buyers, unlike most of the people that make comments on these things. Back when I was selling, I did a substantial amount of business. And I know what it's like to work with a buyer, sign them up to your buyer agency agreement or buyer contract, whatever amount of compensation you and that buyer agree to. For the argument purpose here, for video purpose, we could say, let's say it's 1%, 2%, 3%, 4%. I don't know what it may be. You go out, you show them a number of properties. Then after about a month, and this is more likely to happen right now because inventory is going up in places particularly like South Florida and even other areas of Florida, and in particular with condos. And the buyer starts realizing, wait a second, if I spend $500,000, I can get a condo that was owned by someone else. It was built 20 years ago. But if I spend $600,000, now I can get that new construction. Those units were, I know, selling at $700,000 a year ago. I think I'm interested in new construction. And our agents are getting emails like this. So this is from the Nomad residents in Wynwood, Miami. I don't have any connection to these folks whatsoever, but one of our agents, Gigi, sent me these emails. So then I read it. Exclusive penthouse collection, now paying 8% commission. 8% commission, 6% upfront at contract with a 20% deposit. And then it goes on, it shows the agent information, etc. So let's pretend that you are the agent and you're representing this buyer. You go out for a month, you show them a bunch of properties. A month in, and you got your typical buyer contract signed. A month in, they decide that they want to switch their search to new construction. You go look at this complex, and it's 18 months until it's built. And I'm not saying that one is, but this is the case with many of them. 18 months, 2 years, some as many as 3 years. You go look at it, the buyer says, I want to buy one of these units. I'll rent something for 1.5 years till this is done. Then you get into the meeting and they say, well, we're going to have a meeting today that once you sign your contract, there'll be a meeting, say in a week. And that meeting is going to go over the design or the specifications of the unit. And then 6 months later, there's going to be another meeting where we're going to go over paint colors and finishes, etc. And then 6 months after that, you'll be able to come in and inspect the unit or see it. You're the buyer agent. You're sitting there thinking, wait a second. When they were going to buy a regular condo, this was a 6-8 week endeavor and I was getting paid. Now they're going to buy this new construction. We're talking 24 months before I get paid and there's substantially more work. Hence why these complexes have a tendency to say things like 6% upfront at contract with a 20% deposit from buyer. That's why they say that, because they know that from an agent's perspective and even a buyer, it's like, oh my God, I got to go through all this work. I got to wait all this time. And of course, in the agent in the back of their heads thinking, oh, when am I ever going to get paid on this? Okay. When something like that occurs, that's a major change in circumstance. That's a major change in the amount of work that an agent has to do. Major change in the duration of this client. That is a perfect excuse, in my opinion, to amend a contract. But you've got to make sure as a realtor, you're having an upfront, open, transparent, blunt conversation with your buyer, and they are completely understanding the need to amend the buyer agreement. Now again, make sure you talk to your broker, your legal counsel, and so on. But I am inviting everyone in the industry to think about scenarios like that, because there are many other scenarios. I'm giving one example with new construction, but there are many others. And folks need to be mindful of that. The law professor from Buffalo, why don't you think about that? Mr. Ketchmark, you filed a brief with an opinion and said under no circumstances should a realtor do that. And I'm not saying you said it with those words, but that was the intent and the attitude of the opinion, okay? When you do that, you're the life out of everybody in the business. And even myself in my own company, I'm erring on the side of, hey, agents, don't be amending agreements. Make an agreement with the buyer up front and move forward. Now, fortunately, most of our agents are working in areas that isn't an issue, but it could become one later as inventory goes up, as this market gets back to normalcy from low inventory. There will be more competitive situations, and there will be situations where sellers or listing brokers perhaps are offering more compensation, which is allowed under the law and allowed in most states. I also want to give a shout out to someone else who I do not know. It looks like it's the general counsel at RE/MAX, Ed Kaser. Don't know this gentleman, but he responded to a post that Jack Miller put out. Jack Miller is the president and CEO of T360, wonderful organization, and they also own Real Estate News, and I'm going to mention them in a minute. They're doing a great job on something else. But Jack and James Dwiggins had a conversation about this, and I think James, erring on the side of caution, was just saying it's not permitted, and his post was pretty bold in the wording, not permitted. Well, that might be his opinion. I want to read what Ed said here. You're citing plaintiff's motions and suggestions, memoranda, and you are taking the plaintiff's attorney's vague and unfounded arguments out of context and elevating them to a level that is unhelpful for the industry to understand the nuances of the actual requirements for compliance with the new NAR practice changes. What you are enumerating in your post here and claiming to be the components of the practice changes, in quotes, is not taken from the actual settlement agreement, nor is it referenced at all in the DOJ's position paper either. He's right. context matters, especially in complex litigation. And your post fails to grasp the plaintiff's attorneys are refuting counter arguments in order to get final approval for the big settlement and their big payday. Who's been talking about the payday of these plaintiffs' lawyers longer than me? Nobody. The suggestions motion does not modify the terms of the actual settlement. Then he goes on with some tougher words. But Ed is right. This attorney is right. And we need to be careful what we're spreading around the industry because it scares realtors. Nowhere in the settlement does it specifically say you cannot amend. Leslie said that. Our attorney Michael McDonough said that. Several others that we've spoken to. And if you read what it says, MLS participants working with a buyer must enter into a written agreement before the buyer tours homes. And then they go on with all kinds of details, etc. So I just wanted to go over this because I think that it's very important, and I know the policymakers and those that are involved and those that are putting information out there are likely going to see my video, as well as some of these attorneys. Ed, shout out to you. But I also wanted realtors to hear it and understand that there's some gray area there, and in some ways there's not gray area. It does not say you cannot amend, but then the attorney filed that and it scared everyone. Now, moving on to the next topic. Miss Debra Kamin strikes again. Make no mistake about it, this woman has a problem with the entire industry. But what she does is she twists and she turns and twists the truth and puts out things that aren't accurate. And then yesterday morning and last night, the New York Times put out a correction. Right here, we're going to show it on the screen. A correction was made on December 10th. An earlier version of this article misidentified a grant recipient of the American Property Owners Alliance. Opportunity Matters is a nonprofit that is an affiliate organization of a super PAC that shares the same name and mailing address, not a super PAC. Little confusing. It's in the weeds. Our attorney, Mr. McDonough, gave me a breakdown on what was changed. I'm going to get over that in a minute, but I want to show you this. Front page of the New York Times today. Front page, dead center. Realtors, nonprofit funds conservative groups. So this little correction is going to go in the bottom of the article, buried within this newspaper, okay? And how many people are actually going to see it? But Miss Kamin is once again going to achieve her goal of trouncing on the realtor organization. I think it's time for legal action. I've said it before. I'll say it again until our association, our industry, realtors as a whole start swinging back. We're going to keep, when I say we, all of us are going to keep getting attacked, and it's time for action. Listen, I'm not going to bother or take the time to get into the weeds of where the money was donated, etc. Here's the fact, and I want every realtor to hear it. Over the last 4 years, Democrats have been more difficult with respect to housing. They've done things that have made it much harder on our industry. But I got news for you. Okay, Republicans, don't get excited about what I just said, and Democrats don't get mad. Because when I started getting involved and going to Washington, D.C. and having endless meetings with regulators and banks and mortgage servicers and everyone back in 09, 10, 11, 12, during the foreclosure crisis, Republicans drove me up the wall and down the other side. They were no help whatsoever. So that was a time back then that Republicans were less of a help. And I sure hope, I didn't look, but I sure hope more of NAR's dollars and folks like me that give money to our PAC, I sure hope more of that money at that time went to Democrats. And guess what? I sure hope that in the last 4 years, more money did go to Republicans. The job of the folks that distribute this money is to put it where it best affects housing, where it best affects home buyers, home sellers, and then peripherally, realtors. That's where they should apply the money. In the last 4 years, we've been in a place that Republicans have been better with housing, Democrats have been worse. The President of the United States, Mr. Biden, is on camera 6 months ago saying it's about time realtors lower their fees, okay? The Department of Justice has been nonstop on our industry, nonstop. And the changing administration is going to help housing. That's just a fact. So even if they did, I mean, she's taking $10 million. Folks, NAR puts, and that's over 4 years. NAR distributes about $20 million a year in different areas, okay? And that doesn't even include our PAC and all their other spending. This $10 million over 4 years is a fraction of the overall spend from the National Association. What fraction? I don't know, 5%, 8%, I have no idea what it is, but it's a small amount of money. And the point I'm getting is she's narrowing it in her trash article to cause all these problems and to have a headline like this, okay? She doesn't deserve to be on front page. She should be an editorial reporter because her articles are absolutely full of her opinions and her biased. She shouldn't be an actual journalistic reporter with journalistic integrity because she doesn't have any, okay? So I don't know why anyone reads anything she puts out, but the problem is the New York Times is one of the biggest newspapers in the nation, and what they write, other media follows. Just like on March 15th at 9:50 or 9:35 a.m. when they put out the settlement 25 minutes before they were supposed to because the plaintiff's lawyers leaked it to them. They put it out. Their headline was something to the effect of 6% commissions, no more. That wasn't anywhere in the settlement. But she did that, the Times did that, and what happened? It went downhill to all the other newspapers, all the other online and real estate media nationally. You go read the comments from this article, there's realtors in there going off. And I can't say I blame them. If you only read the article and read the comments and you get sucked into believing what isn't true. I mean, NAR came out, they attacked them yesterday. They come out and asked them to correct it. They put out a correction because obviously there was a flaw in the article, but the damage is done. The damage is done. So realtors, I invite you to go on the New York Times, find this trash and put some positive comments. And why don't you let Debra know what you think about her work? Okay, she's always replying to everyone. I can't get to her on Twitter because she blocked me. I can't get to her on Instagram because she blocked me. So she's good at attacking everyone else. She can give it, she can't take it. I don't block anybody. Anybody out there wants to come after me, go for it. I dare you to. Just know I'll come back at you. I'm not like these defendants in some of these other organizations. Couple more things. As I mentioned, settlement was approved. There have been 3 appeals filed. I don't really think they'll go anywhere, but just wanted to mention that. That's all, my friends. Wanted to update you all. If you have questions, comments, post them in the comment section here on YouTube. For small videos in between these more lengthy ones, follow me on Instagram. Thank you all so much. If I don't see you, Merry Christmas, Happy Hanukkah, Happy Holidays, Happy New Year. Thank you.